Imagine this, a family out hiking, beautiful day, and then, just like that, it turns into an absolute nightmare. Now, think about a former teacher facing the ultimate penalty for what happened that day. It's a case gripping Arkansas, and honestly, it feels like much more than just a trial. So thanks for sharing all these briefing documents and study guides with us. Today, we're really going to dive deep into the state of Arkansas versus Andrew McGann capital murder trial. Our goal here is to kind of cut through all the legal jargon and the complexity. We want to pull out the key insights from these sources you provided, the charges, the strategies, so you can really get why people are calling this more than a murder trial. We'll try to map out a clear path through what makes a capital case like this so intricate, focusing on the tactics involved.
Yeah, when you start reading through the material, the sheer tragedy just hits you immediately. It all centers on the brutal killing of Clinton and Cristen Brink. They were hiking, like you said, with their two little girls, a family day out. And then it ended violently. And the detail that just echoes through everything is that the children were there. They saw it happen. Miraculously, the girls survived. Their parents didn't.
And the person accused is Andrew McGann. He's 28, a former teacher. He's charged with capital murder for both Clinton and Cristen Brink. He's pleaded not guilty. But as the sources really hammer home, the stakes here are just immense. The state of Arkansas is going for the death penalty. That fact alone just changes the whole dynamic, doesn't it? It makes it this huge legal fight.
Absolutely. And it's not like they're just throwing the death penalty out there. They're structuring their case around very specific reasons to justify it. The sources are clear on this. They're pointing to two main aggravating factors.
Right.
These are, circumstances the law sees as making the crime worse, bad enough to even consider capital punishment. And in this case, they've specifically named the brutality of the attack and, crucially, the presence of the victim's children. So right away, that tells you the emotional core and the legal core of the state's argument.
Okay, so when the sources talk about this being a test of capital punishment strategy in Arkansas,
Right.
What does that practically mean? Why this case? What makes it such a test?
That's a really important point. It's not just about getting a conviction for the specific crime. It's bigger. It's about validating Arkansas's entire approach to capital punishment, maybe sending a message. Our sources mention that death penalty cases generally are, rare, expensive, and often emotionally charged. They take a massive toll. So for Arkansas, this particular case becomes a major benchmark. It forces the state to prove its death penalty system works, that it's fair, under intense scrutiny, public and legal. Any mistake, any procedural error, any challenge to evidence that sticks, that could ripple out and affect future capital cases there. It's a real high-wire act for the prosecution, especially considering the resources and the legal hurdles involved.
That makes sense. So the prosecution has this double burden, right? First, prove guilt beyond a reasonable doubt, which is already tough. But then they also have to convince the jury that these aggravating factors, the brutality of the kids being there, outweigh anything the defense brings up as mitigating circumstances. How does that balancing act work in court?
It's really a constant push and pull, a strategic battle. The prosecution, they'll be painting a picture relentlessly of extreme brutality and the devastating impact. They'll keep coming back to those aggravating factors, double murder, children present, to argue that the crime itself demands the ultimate penalty. The defense, on the other hand, they might not dispute that something terrible happened, but they'll focus on mitigating circumstances. Okay. These are factors they argue should lessen McGann's blame, or at least argue against execution. Things like maybe his background, his mental state at the time, perhaps a lack of a violent history before this. They try to humanize him. They want the jury to see reasons not to impose death, arguing for life imprisonment instead, and the jury. They have to weigh all of that. These two very different, compelling stories. It's incredibly complex legally and, ethically. Makes the whole process very demanding.
Okay, given those huge stakes, let's maybe zero in on the key people involved here. At the center, obviously, Andrew McGann, the defendant, sticking to his not guilty plea on these capital murder charges. And then the victims, Clinton and Cristen Brink. Their deaths are the entire reason for these charges.
Right. But the sources really highlight that the most emotionally significant and probably strategically critical witnesses are the two young daughters. Their survival is incredible, but it means they were there. They witnessed the attack. Their testimony, which the sources call crucial, isn't just about facts. It powerfully underlines that aggravating factor, the presence of the victim's children. It brings up really tough questions about using child testimony in such a heavy case and how both sides will handle that very, very sensitive aspect.
Absolutely. And then you have the legal teams, the state of Arkansas, the prosecution, pushing hard for the death penalty, using all the state's resources, and facing him, Andrew McGann's defense team. Their job is to challenge everything, every piece of evidence, every argument, and ultimately try to save his life. It really is set up to be a clash of legal minds.
And that clash starts way before any jury hears opening statements. Our sources talk about the pretrial proceedings. These aren't just procedural hoops. The documents call them crucial. Why? Because they shape the trial before it officially begins. This is where so much of the groundwork is laid, and sometimes the biggest legal fights happen outside the actual courtroom.
What kind of groundwork are we talking about? I mean, what happens in these pretrial stages? I guess the defense is really active here, trying to weaken the state's case early on.
Oh, definitely. You expect the defense to file a lot of motions? These are formal requests to the judge. They'll likely challenge how evidence was collected, was it done properly, can even be used in court, that's admissibility. They might also go after certain witness testimony, arguing it's unreliable, maybe legally flawed in some way. And a big one you often see in cases with lots of media coverage is a motion for a change of venue, basically arguing that McGann can't get a fair trial locally because of all the publicity or potential bias, so the trial needs to move somewhere else. These motions aren't just procedural, they can really change the whole playing field.
Okay, so all that leads up to what feels like the real gauntlet in a capital case. Picking the jury. The sources call it a marathon. Why so long and intense for jury selection here?
It's a marathon because the decision these jurors might have to make is literally life or death. So, unlike other trials, jurors in a capital case, as the sources say, must be capable of fairly weighing a death sentence. That means finding people who aren't automatically against the death penalty, but also aren't automatically for it either. They have to be genuinely open to considering both life imprisonment and execution based only on the evidence and the law presented in court. Both sides, prosecution and defense, go through this rigorous questioning process called voir dire. They're looking for any hint of bias, any strong beliefs, anything in a person's background that might sway them unfairly. It's exhausting, and it's deeply strategic. Lawyers are trying to figure out how someone might react to, say, graphic evidence versus potentially moving mitigating factors. Who ends up on that jury? It can absolutely determine the outcome.
So the stage is set, the jury's picked, and then the trial itself unfolds. The sources frame it as this collision of legal skill and emotional narrative. What does that collision look like from the prosecution side? What's their story?
Well, the prosecution's playbook, as we anticipate from the sources, is to lean heavily on the brutality and family impact to justify the ultimate punishment. What that means is they'll likely present the evidence very methodically, detailing the violence of the attack itself, make it visceral. And critically, they'll weave in the story of the family, the impact, especially highlighting the trauma for the daughters who were present. If the children's testimony is allowed, they'll use it not just for facts, but to connect with the jury on an emotional level. The goal is to show that the crime was so heinous, so devastating, that the death penalty is the only just response, making those aggravating factors really hit home.
That sounds incredibly powerful, focusing on the horror and the loss. How does the defense possibly counter that without looking like they're dismissing the tragedy? What's their narrative?
That's exactly the challenge they face. It's a very fine line. The defense strategy, according to the sources, will likely focus on undermining the timeline, forensic links, and challenging whether the state can meet the very high bar for execution. So, they're less likely to dispute that a terrible crime happened and more focused on creating reasonable doubt about whether the prosecution has proven beyond that doubt that Andrew McGann did it and did it in a way that warrants death. Forensic links, that's the scientific evidence, right? DNA, fingerprints, maybe digital evidence, ballistics. Yeah, exactly. The defense will pick apart how that evidence was handled, tested, interpreted. They'll look for weaknesses, alternative explanations, anything to suggest it's not as solid as the prosecution claims. Their main goal is to plant seeds of doubt, make it harder for all 12 jurors to agree on guilt for capital murder, and especially harder to agree on execution. And they'll fight hard against the idea that the aggravating factors automatically win. They'll present their mitigating factors and argue strenuously that those outweigh the reasons for death, hoping to persuade at least one juror towards life.
Okay, so just to kind of wrap up our deep dive today on State of Arkansas v. Andrew McGann, we've looked at the awful crime against Clinton and Cristen Brink, the capital charges against McGann, and the incredibly high stakes involved with the death penalty being sought. We've also unpacked why this trial feels like more than just one case, how it's seen as this major test for Arkansas's capital punishment strategy. And we've walked through the legal chess game ahead, the pretrial maneuvering, the intense jury selection process, and the competing strategies we expect to see play out between the prosecution and the defense in the courtroom. It really makes you think, doesn't it? This case isn't just a legal proceeding. It's a stark look at how our justice system grapples with the absolute worst when the stakes are truly life and death. What do trials like this really tell us about the complexities, the deep emotional toll, and just the immense demands placed on everyone involved when the ultimate penalty is on the table?